Be ready for dictation at the speed of 100 words per minute. 5 seconds to go. Start. The learned council has, while extensively relying on the Constituent Assembly debates, preamble, and Article 38 of the Constitution, which enjoins the state to secure and protect a social order in which justice, social, economic, and political shall inform the institutions of the national life, stressed that it was to ensure this social justice and the ethos of the Constitution that special provisions were envisioned under Article 15.4 and reservations in employment were provided under Article 16.4. He argued that it was due to certain primordial practices that a section of population was marginalized and was deprived of material resources and educational opportunities. The people in the lowest strand of social hierarchy were ostracized and stigmatized from public life and were deprived of basic liberties and equality. It was to address these historical inequalities that, as a vehicle of positive discrimination, the socially oppressed sections were provided reservations and special provisions so as to give them a voice in administration, access to resources such as education and public employment. Therefore, the idea of ensuring social equality and justice was a congenital feature of the Constitution shaping its basic structure. The Learned Council has argued that this basic structure has been violated by the amendment in question, which seeks to empower the privileged sections of society who are neither socially and educationally backward nor inadequately represented. He also submitted that the amendment in question has introduced those sections of people as economically weaker who were never subjected to any discrimination, whether historically or otherwise, and were not backward socially and educationally. The learned counsel quoted from the Constituent Assembly debates to support his contention that reservation should not be used by the forward class as a self-perpetuating mechanism, depriving the disadvantaged. The equation of the victims of social discrimination with those responsible for their victimization for the purpose of conferring benefits was a contortion of the Constitution and no less than playing a fraud on it. The learned counsel has further submitted that the non-obstant clause in Articles 15.6 and 16.6, while granting reservation to already privileged and adequately represented class of citizens, has vetoed the prerequisite of being socially and educationally backward or inadequately represented, which was the kernel to philosophy of reservation. The Constitution puts forth social and educational backwardness and not social or educational backwardness as a criterion to determine positive discrimination in favor of a class. This foundation of social justice for historically marginalized and disadvantaged people is completely obliterated by the amendment in question, which removes that criterion. He argued that backward class included those classes from the forward class that were socially and educationally backward, hence making them eligible for benefits of reservation. He exemplified this by stating that there were numerous communities traditionally belonging to the so called forward class in several states, and several of those are not professing any religion but are recognized as other backward classes on the ground that they are socially and educationally backward. The Learned Council has yet further argued that the purpose of positive discrimination was to put an end to monopoly of certain classes and create an inclusive society so as to ensure equality of opportunity to the marginalized sections. However, the amendment in question creates a perpetual monopoly by providing reservation to that section of population whose identification is imprecise and is based on their individual traits, more so when these classes have been enjoying and are still enjoying control over resources and public employment. Lastly, the Learned Council would submit that the amendment in question is not based on economic condition which is multidimensional but on financial incapacity which is transient in nature, rewarding poor financial behaviors and is therefore not a reliable criterion for giving reservation. There are two wings of reservation: social and educational backwardness, which cover the people who are economically weaker but not those who are financially incapable. Economic weakness goes hand in hand with social and educational backwardness. The Learned Senior Council elucidating on the twin objectives of Equality Code enshrined under Articles 14 to 17 of the Constitution as to the formal equality and substantive equality has submitted that these provisions are to ensure that those sections of society who have been kept out of any meaningful opportunity participation in public life and decision making on the grounds enumerated under Article 15(1) be uplifted through positive discrimination, giving flesh and blood to the Equality Code and essentially enabling the substantive equality, emphasizing on the efficiency in services as under Article 335. She would submit that the positive discrimination has to be read along with other guardrails provided by the Constitution, ensuring identification of the protected group by constitutionally sanctioned bodies